Well, good afternoon. Thank you all for being here. I'm Bill Powers. I'm the president of the University of Texas at Austin. As you know, the Supreme Court today decided the Fisher versus University of Texas case. I will make a brief statement, and then there'll be statements from two other people here with me up at the podium, and then we'll have time for questions and answers. Let me first introduce the people who are here with me. Michael Uggio Williams, the Vice President for Student Government, who is a senior here at the University of Texas at Austin. Andrew Clark, President of the Senate of College Councils, who is also a senior here at the University of Texas at Austin. Patty Ohlendorf, Vice President for Legal Affairs here at the University of Texas at Austin. Kedra Ishop, Vice Provost and Director of Admissions. Greg Vincent, Vice President for Diversity and Community Engagement here at the University of Texas at Austin. Let me read the following statement, and then you'll hear from Kedra Ishop and Greg Vincent. We're very pleased with today's Supreme Court ruling in this case. We're particularly heartened that the framework laid out by the Grutter case remains in place, not just for the University of Texas at Austin, but for higher education institutions throughout the United States. There were a number of directions that the justices could have turned in today's ruling, and this 7-1 ruling represents a positive outcome for this university, for the state, and for the nation. We at the University of Texas will continue to defend the university's holistic admission policy on remand in the lower court under the strict scrutiny standards that the court first articulated in the Bakke case and reaffirmed in the Grutter case and laid out again today. We're confident that the university's policy and procedures fully satisfies those standards. And using the guidance provided by the justices, we will make that case in the Fifth Circuit on the remand. One of the issues in the case today was the proper standard of review. That standard is strict scrutiny. Strict scrutiny is the case or the standard that we have argued this case from the beginning. This is a standard that we think the Fifth Circuit did and intended to review, and we will make the case that we meet the strict scrutiny standard when we get back to the Fifth Circuit. Today's ruling will have no impact on admissions decisions that we have already made or any immediate impact on the holistic admissions process at the University of Texas. The university is a leader in diversity in higher education, and this case is part of a decades-long commitment to that endeavor, both inside and outside the courtroom, by all of us here at the university. We remain committed to assembling a student body at the University of Texas at Austin that provides the educational benefits of diversity on our campus while respecting the rights of all students and acting within the constitutional framework established by the court. Thank you. That's my statement. Now let me turn it over to Kedra Ishop, who I said earlier is the Director of Admissions here at the University of Texas.
Good afternoon, everyone. It's a pleasure to be here today. As President Powers has already alluded to, there have been significant concerns over the course of this case, especially given the timing regarding its impact on the entering class of 2017 or moving forward to the class that we've begun recruiting for to be admitted for 2014. And as the President has said, the structure of this decision does not change the admissions process for the students that we will be reviewing for the upcoming class, and there will be no changes to the decisions that have already been made. And we'll continue with our admission process that looks at a multitude of factors in review of students for admission into the University of Texas at Austin. Thank you.
Good afternoon. I'm Gregory Vincent. As President Powers shared, we are very pleased that the Supreme Court, in its 7-1 decision, left intact the framework laid out in the Grutter decision that, of course, affirmed the Supreme Court decision in Bakke in 1978. And so we will continue to use that framework, and we believe that the benefits of diversity certainly benefit all students here at the University of Texas, and indeed all throughout higher education. We believe that we have the sufficient evidence, as we've argued throughout the entire case, to show that we have met the standard of strict scrutiny, and will continue to make that argument in the proceedings as the case gets remanded back to the Fifth Circuit. Thank you very much.
Okay, now we'd be open to taking questions. Yes, ma'am.
How is the university planning on proving that UT is meeting standards of strict scrutiny once you get confirmed with the court again?
Well, the case has been litigated under that standard all the way through. The justices want to make sure that's the standard with the language that the Fifth Circuit used, that's the standard the Fifth Circuit used. There are issues of deferring to our judgments versus applying strict scrutiny. We think we've met those. We've litigated the case all the way through. This is a compelling goal. We have narrowly tailored our processes to use ethnicity as necessary to meet compelling educational goals. That has been the strategy of the litigation all along, and we will, in my view, continue to meet that. Yes, sir.
I noticed in the ruling today there was no discussion of the 25-year rule mentioned in the previous Grutter decision. How does the university feel as a temporal kind of goalpost? How long does the university intend to use race in admissions, and is there a time when the university would deem race not to be a factor to be used in the admission process?
Well, the compelling goal is to have a diversified student body inside and outside the classroom for the benefit of all of our students so that they receive an education in an educational context that is preparing them for work in an increasingly diverse and global world. In my view, we still have work to do on that. We will continue to study and monitor and look at that. And when, for the future, certainly the near future, we think the use of ethnicity is necessary under strict scrutiny to achieve that compelling goal. When we get there, I think we all hope that our society gets to a point where that may not be necessary, but we're not there yet.
Are challenges to this policy, are they useful, are they helpful, do they help refine the policy?
Well, I think our Constitution is the bedrock of our civic way of life, and our litigation system is an important part of that bedrock, our court system. And so having these issues resolved under the rule of law in our courts is certainly one of, in my view as a lawyer, one of the very great blessings of the way we go about business in this country. Certainly it is also important that all of our public institutions are held accountable for making sure we're using the right standards. And so I do think litigation of this sort, which we think we are on the proper side of and are absolutely following the constitutional standards here, but that is the way we resolve issues like this in the United States, and I think that's a healthy thing to do.
President Powers, your reaction to having
Well, I think this case, it has been remanded to the Fifth Circuit. It's not over. This keeps in place the structure of Bakke and Grutter, which is the position we have taken all along. As I said earlier, we think strict scrutiny is as is in cases of race in constitutional law in the United States, the correct standard, and certainly the standard that we've been arguing this case under. It will be sent back to the Fifth Circuit to clarify some points about that. As I said, I think we are absolutely in compliance with that standard, with our position. We'll go back to the Fifth Circuit to resolve that issue. I think the important thing about this case is that it leaves intact the Bakke-Grutter framework that narrowly tailored use of ethnicity is constitutionally permissible for institutions of higher education. Other?
The Supreme Court said that you incorrectly used the wrong standard in order to win a summary judgment, so it has to go back to the Fifth so that they can actually use the strict standards.
Well, we think there's the issue of deference to judgments we made. Supreme Court wants to make sure the Fifth Circuit was using precisely the right standard, but that is the standard that, as I said, we litigated the case under, and we're prepared to litigate the case under that standard in the Fifth Circuit.
There are some observers who believe that this ruling is actually a compromise between the doctrinaire conservatives and liberals. Conservatives feel that now affirmative action would be much harder to implement, and then for the liberals, at least affirmative action lives to see another day. What do you think about that?
Well, I think that this case, as I said earlier, does leave intact the Bakke-Grutter framework, which does permit the use of ethnicity under the right circumstances. The case is really how are we going to go about deciding whether whether the right standard is used. That will be clarified, but the basic standard that they are sending back to the Fifth Circuit is the standard that we litigated the case under from the start, and we'll continue to do that. I think the whole area from Bakke onward has been, I don't know, I wouldn't use the word compromise. It has been navigating for the court a pathway that allows the use of ethnicity, but not in an uncareful way, such as with quotas or targets or implements of that sort. This has been an issue of central concern to the United States for over 50 years, and I think the court, the Supreme Court and the lower courts have charted a pathway that is trying to respect a pathway that makes good on both sides of that point. But it does, this decision leaves intact that pathway.
You have time for one more question?
Yes, ma'am.
Do you think the success of the top 10% program will make it difficult to argue that in achieving diversity will make it difficult for the university to argue it needs an affirmative action program on top of the top 10% program?
Well, the automatic admissions program, and this has been an issue of a great deal of work in the state of Texas for a long period of time, and certainly over the last 2 or 3 legislative sessions, is one tool to help diversify our campus and higher education across the state of Texas. As you know, we are in a position with our increasing applications and the increasing size of the graduating classes in the state of Texas, that we are getting to the point where virtually all of our students were coming in under automatic admissions. That is unhealthy. There are other criteria. As important as high school performance is, there are other criteria that are also important. Leadership, skills in particular areas. So that having half the class come in under automatic admissions is healthy. Having the entire class come in under one criterion is not. So there are important educational goals that we are able to have a portion right now, 25% of our class, come in under a full set of criteria, like, frankly, people being admitted to colleges all across the United States. For that group of students, it is also important that narrowly, that is the group of students who do not come in under automatic admissions, that group of students also be diverse under a narrowly tailored use of ethnicity that is passes constitutional standards under strict scrutiny. That's been the position we've been taking. The Supreme Court did not say we have not done that. That also is an important educational goal, that not every single one of our students be admitted under one criterion, that is their rank in their high school class. Okay, thank you all for your being here and your attention to this very, very important issue. Thank you.